I'm going to quickly take you through Malaysia and also Indonesia. So here's to give you an overview of the current amendments that is currently going on. And as we know, Malaysia is one of the early countries in ASEAN to actually pass a law in 2010. And because of, and now we're actually going through the amendments. If it's not for the change of government 4 times in 2 years, we probably have passed through the amendments, some of you following the Malaysia law. So some of the things that we've actually looked into in the amendments is the mandatory designation of a data protection officer, the current law, and also the mandatory data breach notification. So over the years, there has been quite a bit of data breaches that has happened in Malaysia, and surprisingly, the numbers are actually in the millions. The data breach number of records are actually in the millions. So the next thing that to take note of is the blacklist to replace the whitelist in terms of the cross-border transfer mechanism. So now we have a whitelist which allows you to transfer information over to a whole list of countries which is approved by the supervising authority. And now they are coming out with the blacklist where it's going to be a bit concise, more concise in terms of the list of countries that's not allowed to be transferred to. Right. So here's to give you an overview of the Malaysia PDPA compared to the EU GDPR. The current Malaysia PDPA is based on the EU 95 directive, so you may see some sort of similar content there. But the Malaysian law is focused a lot more on the consumer rights, as what Kevin mentioned, the ASEAN countries. The law that was passed in 2010 was actually to facilitate the national e-commerce master plan back then. And one of the requirements under the Malaysian law is to have the data users registered with the regulators. And I mentioned earlier on the blacklist, in terms of sanctions, current process is actually to go through the judicial court, but what they found out is actually a hassle. And now they've actually introduced something called the compounding fines, where if it's a clear-cut breach or non-compliance, then in a way, you have a negotiation session with the regulators, right? So you can negotiate how much the penalty you want to, or the fines that you want to pay. All right. So to give you an overview in terms of the key differences on the Malaysian law is we focus on the consumer rights. The lawful base is always on the consent. And some of the challenges that we face under the Malaysian law is actually the lack of knowledge and awareness amongst the industry in Malaysia. So if you happen to go to Malaysia, and if somebody asks you for your information, it's actually expected for you to just give your information, right? So if you were to ask me for my information, I'll just happily give it to you. So that's the culture in Malaysia. So don't be shocked if you hear friends that actually happily gives out information out in Malaysia. And the other issue is the lack of enforcement, the issue of the independence of the regulators in Malaysia. It has been since overdue that the current regulators are supposed to be transformed into a commission status or independent status. And the reason it being because of budget issues. There's been quite a bit of change of government and the lack of resources. I think these are the issues faced with the regulators around the world. Okay, so here's to give you a summary in terms of whether or not the Malaysian law has taken the adoption or the adaptation approach to GDPR. So I'm going to take you through, so let's move on to the next jurisdiction, which is Indonesia. Indonesia's law was passed in October 2022, very recent. And the regulators there have given the industry approximately 2 years to put things in place. And it covers both the private sector and also the public sector, right? So it's pretty much similar to the GDPR aspect of it. Now, the Indonesian law covers the fundamental human rights, which is similar to the GDPR. And they have something what we call a special rule on visual data processing devices. So all devices that has things like your CCTVs and so on, they have actually special rules that requires the organization to put certain rules in place. And then we talk about the data subject rights or data subject requests. The organization have to comply 72 hours to respond to a data subject request, right? So this is something to note of if you're operating in Indonesia. The window is very tight. Make sure you have your processes in place to address the 72 hours window. And yeah, right. So that is a comparison of the Indonesia personal data protection law compared to the EU GDPR. So now the key difference here under the Indonesian law is where you look into the 72 hours response to a data subject request, and also the rules of visual data processing in Indonesia. The current challenge that the Indonesian regulators are having is actually the lack of clarity in terms of how the implementing regulations, which is yet to be published. And my last conversation with the regulators said that given they would probably establish some sort of implementing rules within the next year. And the challenge of organizations in Indonesia, where it covers both the public sector and also private sector, the window of 72 hours time frame to address a data subject access request. So earlier, for those of you who have answered the time frame on the data subject access request in Indonesia, surprise, it's 72 hours. Right. All right, so here's a summary of the adaptation to the GDPR, looking into the Indonesia's personal data perspective lens.